with the police department. There was a letter dated 5th of July 2004, which was produced as Exhibit 4, authored by the first respondent, which the prosecution alleged was the first contact to the police department on the contract. The letter came several months after the contract had been executed. This is an area the court cannot close its eyes to without calling on the author of the letter to explain the circumstances under which the letter was written. The same goes for the fact that the contract was executed on 17th of December 2003, yet the approval was given on 23rd of December 2003. From the above evidence, it is clear to me that there needed to have been an explanation whether the police department was involved in the consultation, and the only person who could do that were the first third respondents. Based on the above, I hold that the first, second, and third respondents should have been placed on their defense for the court to test whether or not there was consultation with the procuring entity and whether there was a defined method of procurement, and if so, whether the same took into consideration the interest of the economy and efficiency. The way the Honorable Magistrate did the analysis on the issue of consultation was, in my view, not within his purview, and he seems to have allowed himself to wander into the field of the respondents. The comments he made in regard to the issue amounted to an explanation of the circumstances under which the contract was signed, which should be done by the first, second, and third respondents. The first, second, and third respondents were said to have executed the agreement when there was no budgetary provision of the project. On the issue of the budget, one need to look at the evidence of PW 8 and 21. I have looked at Exhibit 10, 11, and 35, which were relevant to the issue of the budget. The third respondent authored Exhibit 24, and again is the only one who could give explanation on the import and purpose and consequences of contents therein. The second respondent wrote letter dated 9th of September 2003 to the first respondent, which stated in paragraph 3 that there was no budget provision for the particular project. There is also a letter dated 3rd of December 2003 in which the first respondent at paragraph 3 suggested that there was no budget for the project and was seeking to utilize supplier credit arrangements. In my opinion, that meant there was no allocation for the credit financing for that year. The respondents have made submissions to the issue of lack of budget in reliance to what the prosecution witnesses said in the cross-examination and put emphasis on their position that the first to fourth respondents would be respondents would be within the law to reallocate funds from one vote to another. Whereas the said respondent may have had the discretion to reallocate, I do believe that the items of the budget set to benefit from the reallocation should have been part of the budget or plan. I do not want to go deeper into this analysis on this, as I may risk getting into the defense case. I, however, find and hold that the trial court did not adequately, in my view, analyze this aspect. It is this court's ordering that the prosecution had established a prima facie case that there was no budget or prior planning for the project. I'm left with the count 2 and its alternative, which is against the fourth and fifth respondents. The counts were hinged on the fact that the respondents dealt or utilized funds sent by the government of Kenya to account number 602409 held at Schroders and Company Bank AG Zurich, Switzerland. For this charge to stand, there must be demonstration that the said respondents knew or had reasons to believe that the funds were proceeds of corruption and went ahead and received it. The appellant maintains that the fourth and fifth respondents knew that the money was paid to their accounts corruptly. It was demonstrated by the prosecution that the company was paid 1.2 euros and was linked to the fourth and fifth respondents as beneficial owners. The contract in question was signed on behalf of the supplier by one Brian Mills, who was removed from the proceedings. The fourth and fifth respondents were not players in the procurement of the contract. The money was not paid to the supplier, but to Apex Finance Corporation, which I will hereafter call Apex. Apex was not a party to the contract, although the contract at clause 8b provided that the money was to be paid to its account. The payment slips confirms that the money was paid to the said company's account. Apex not having been a party to the contract, there must be a justification of why they got the money and dealt with it if they were not part of the conversation. The fourth and fifth respondents who were signatories to the Apex account cannot claim ignorance of the contract, having received such an amount of money. I do not accept that a genuine company would just receive such funds and deal with it without bothering to know the source of the same. Apex did not, on the face of the evidence, provide any service, and the receipt of the said money must be explained, especially when it comes from government funds. No person is better placed to answer those issues than the fourth and fifth respondents. They should convince the court that they were not aware and did not have reasons to believe that the money was corruptly transferred to the account to which they were signatories. There is evidence that the fourth and fifth respondents were directors of the company when it was incorporated in Mauritius on 8th of January 1998, and when it opened the account to which the money was sent. There are also declarations of trust dated 17th of October 2001 by shareholders of Apex showing that they held the share therein as nominees of the fourth, fifth, and now deceased sixth respondent. Client profile for Apex dated 1st of October 2006 shows that the same respondents as beneficial owners of the account. The prosecution claimed that the fourth and fifth respondents were signatories to the account when the money was received. The fourth and fifth respondents have submitted that they had resigned from the company by the time the money was received, but the prosecution maintains, and there is evidence to that effect, that fourth and fifth respondents remain signatories to the account. By remaining as signatories to the account, the fourth and fifth respondents must, in absence of evidence to the contrary, have remained as beneficial owners of the account. In my view, the evidence to the contrary cannot be adduced through submissions. The said respondents should take the stand and produce evidence. Finally, there is a dispute on whether the contracted goods were supplied. The respondent insists that since there was lack of appendix to Exhibit 2, there could not be certainty as to what was to be actually delivered. The prosecution, on the other hand, maintains that the goods shown to have been delivered were not associated with the contract in question. If indeed the lack of the appendix made the contract incomplete, then what would have been the basis for payment of 1.2 million euros? If indeed there were deliveries, the suppliers is expected to have copies, and the respondent should be expected to explain this in their defense. Whereas this court appreciates the position that the burden of proof lies with the prosecution, there are instances where the accused person must be called upon to explain their roles and positions in the claimed state of affairs, which can only be done during defense hearing. The upshot of the above is that this court finds that the prosecution had established a prima facie case against the first, second, and third respondents in respect of counts 3, 4, 5, 6, and 7 as respectively charged, and against the fourth and fifth respondents in respect of count 2 and its alternative. And I hereby set aside the trial court's ruling dated 19th January 2024 and order in place thereof that the respondents are hereby put on their defense in respect of the mentioned count. The acquittal in respect of count 1 is hereby upheld. The respondent shall appear before the Chief Magistrate at Anti-Corruption Court on a date to be fixed after this judgment for further directions on the defense hearing. As I conclude, it should be understood that nothing in this judgment should be construed as a direction to the trial court to conduct the defense hearing in a certain manner. Neither is there a conclusion to the authenticity and the strength of the evidence so far produced. The matter and the final decision thereof shall be in the discretion and control Ms. Muller, when are your clients back?
My lord, I will have to confirm with them and then let the court know.
They are online. Mr. Kamani, Deepak, and Rashmi, when are you back to the country? And Rashmi, you are muted.
Yeah, Your Lordship, I can be back whenever you request. I'll make an effort, definitely.
Senior Counsel, which date is convenient?
Lord, date like Wednesday next week. The High Court is going on vacation. Wednesday or Thursday next week would be convenient, my Lord. subject to Manane friends.
My lord, is on the 6th. Thursday is on the 7th.
Could we take 7th, Thursday?
The law court matter shall be mentioned before the Chief Magistrate on 7th of August 2025 for further directions on the defense hearing, or the respondents to appear in person.
Thank you, my lord. We have
Thank you.
clearly understood.
Thank
Thank
you.
you.
Good day.
Thank you.
Thank you, Judge. Wish you a good afternoon.